Good afternoon, everyone. Thank you so much for attending. My name is Mike Wagner. I'm senior counsel with Jacobowitz and Gubitz. I practice elder law and estate planning, and today we're going to focus on estate planning made simple, what you need to know. We've done seminars on these topics really all over the Hudson Valley and New York, but these days we're doing webinars and we're really having fun. So please feel free to enjoy the interactive features that we have. You can chat, you can ask questions if you look at the toolbar on the bottom of your screen. A little bit about Jacobowitz and Gubitz. We've been around for more than 50 years. We have more than 35 areas of practice. Our office is located at 158 Orange Avenue in Walden, but we have availability in the office to meet with clients. We are reopened, but we are also doing meetings online on Zoom. I do want to mention right at the top here that for the time being, we're able to do entire estate planning signings on Zoom. We're able to witness and notarize wills, trusts, and other estate planning documents. So it's good to know that you're able to do your estate planning safely and remotely. Okay, I want to outline the agenda for today. We're going to do estate administration as part one. Part two is going to be keeping assets in the family, the bloodline, so to speak. And part three is Medicaid asset protection, a very important topic. That's the reason a lot of people go to these webinars. So the first question on everyone's mind is, what is a will? A will is a set of instructions for death. A will states, when I pass away, my assets will go here and here and here. And a will is a document that people complete, and then maybe they look at it now and then, they put it in a drawer, and the family takes it out at the appropriate time when someone dies. Wills go to the county surrogates court in Orange County, that's in Goshen, and they are subject to a process called probate, by which the executor has to be formally appointed in the role, which we'll talk about in just a moment. So wills basically govern what happens to your property when you pass away. What is a trust? A trust is a little bit different because a trust is a living estate plan. Whereas a will says what happens when you die, a trust is existent right now in 2020 when you make it. A trust is more like setting up a company for yourself. The trust exists during your time right now while you're healthy and well. It's durable and continues to exist in the event of disability. And a trust also exists after you pass away. It works as an alternative to a will and can distribute your assets according to whatever set plan you devise. And the important thing to note about trusts is that they don't go through court. So whereas wills are just a plan for death, trusts are a plan for while you're healthy and well, if you become disabled, as well as ultimately when you pass away. So let's get into estate administration. There's two topics to cover here, probate and trust settlement, and what exactly is the difference? We said probate means court. When someone dies with a will, it goes to the county surrogates court. This takes time. Usually it takes, under the best of circumstances, at least a few months from the date of death to the date of the appointment of the executor. So in other words, the executor is not automatically entitled to act just because they're named in the will. The executor has to petition the surrogates court to have the right to act on the decedent's estate. So it takes some time and it costs some money. The legal fees are typically significant for a probate proceeding depending on the complexity of it. It can be percentage-based or flat fee-based or hourly-based, but whatever it is, going to probate involves attorneys and typically costs money. Also, it's public. So you might wonder why celebrities' wills end up on the internet. It's because wills are public record. When someone dies with a will, it basically gets submitted to the court, and it goes on file there and it's accessible. So if you've seen a will on TMZ before, it's because someone went to the county surrogates court and downloaded a copy of it, and it is public record. Trusts work a little bit differently from that. When someone has a trust and they pass away, there is no court proceeding. Everything is handled privately, basically in the family. In other words, there is no need for a court and a judge to adjudicate where the assets go. The trustee isn't formally appointed by the court. The trustee can act immediately, usually within a few days or a few weeks of the passing. Real property can be sold, taxes, if any, can be paid, and the estate can be settled quickly. It typically, because it doesn't involve court, it costs less money. Setting up a trust might cost more than setting up a will while you're living, but after you pass away, having a trust is actually a lot less expensive because there is no need to go through court and the process is streamlined and more efficient. So it saves some money. It's also private. Whereas you see wills on the internet sometimes, you're not going to see a copy of a trust there because trusts are handled privately outside court. They are not part of the public record. So it's important to note that trusts do not get distributed. So if you're concerned about the privacy of your estate plan and keeping what it says within the family, a trust may be the way to go. So I'm not here today to tell you that nobody should ever do a will. We do lots of wills for clients every month. Wills are a great solution for young people who are starting families and buying homes and want to name a legal guardian for their kids and set up a plan in case they pass away. So wills are a good solution for that. And wills can also be a good solution in straightforward estates where there's no problem in the family, everyone knows everyone, gets along, and there's no issues. Sometimes going through probate is not the end of the world, right? I'm not here to say nobody should have a probate proceeding, but I am going to say that trusts can work more effectively and efficiently in certain circumstances. For example, suppose someone does not have children. If you don't have children, who's your next of kin? Could be your parents, but maybe they've passed away. Could be your nieces or your siblings, but maybe there aren't any. Could be nieces and nephews if they're around. Could even go as far as cousins. But the fact of the matter is the next of kin has to be involved in a probate proceeding, regardless of who you leave your assets to in a will. Whether you leave them to charity, whether you leave them to friends or family, regardless of where you leave your property, the next of kin has to sign off on the probate proceeding. And the issue is your next of kin might be quite far away from you and you might not have a relationship with them, especially if it's down to the level of cousins or beyond. And we've had a lot of cases where people don't even know, the executor of a will doesn't even know who the family is. So we have to hire genealogists and do research, publish in the newspaper. There's a lot of situations where, this is all avoided by just doing a trust and avoiding probate. So in cases where someone does not have kids, that's a good situation to consider a trust. In cases where you have an heir who might contest your wishes, that's a good situation to do a trust. Trusts are very difficult to contest. They're hard to challenge. We can put a clause in trust that says if anyone tries to challenge, they're to end up with nothing, not even what you otherwise left them. So if you leave somebody 10% and somebody 90%, and you don't want the person getting 10% to contest your wishes, that's a good way to go. And there's no court proceeding inherently involved like a probate. So trusts are difficult to contest, and they're very secure estate plans if you're concerned about your wishes being contested. If you own property in more than one state, that's a good reason to consider doing a trust rather than a will, because the estate has to go through probate, not just here in New York, but everywhere where you have property. So if you have a house in New York and then you also own a condo or something in Florida, the estate has to go through probate first here in New York and then a second time in Florida or wherever else you own property. So that's a very serious consideration. If you have property in more than one state, you should look into doing a trust rather than a will. Another instance, which we're going to get into in just a few minutes, is Medicaid asset protection. Medicaid asset protection is a very important reason why people do trusts rather than wills, and certainly something to consider. Okay, there's a couple of questions here I want to see if I can address. Can a property with a reverse mortgage be transferred without triggering repayment? So that's a good question. With a federal, there's a federal statute about mortgages called the Garn-St. Germain Act that basically states that a property with a mortgage on it can be transferred to a trust, and the bank cannot call in the mortgage so long as certain provisions are met. So we do transfer mortgaged property into a trust all the time. It is common. Reverse mortgages are a little bit different, and there's a lot of rules that go along with them. So I'd want to talk to you specifically about that. The answer is a qualified yes, but there are more details that we need to discuss. There's another answer about corporate. There's another question about can a trust own a corporation? It's a simpler way to put it. The answer is yes. There can be language for a trust to own an S corporation. We'd have to talk in greater detail. The question asks some more specifics, so I'd ask the person who asked the question to email me after the presentation today. Okay. I want to go to part 2 now, which is keeping assets in the family. Very important. So just about everyone who comes to my office when they come to do estate planning, they've worked hard their whole lives. They've earned these assets. They want to pass them down to their children if they've got kids, or whomever their closest family may be. But a lot of people are not so crazy about the son or the daughter-in-law. And even if they like the person, even if they like the son or daughter-in-law, there's a concern about, you know, what happens if you leave everything to your daughter and a few years down the line, after she's inherited everything and done everything she has to do, gotten the money in her own name, she gets sick and she has an untimely passing of her own. If that is the case, the concern is that she's got a will that leaves everything to her husband, right? And then the assets have moved sideways, and he's still relatively young, so he gets remarried and he has stepchildren, and now the assets are in someone else's family. That's an estate planning nightmare. That's what nobody wants to see happen. When we're talking about estate planning, nobody wants to see the assets move sideways into a stepchildren sort of situation. Everyone wants assets to stay in the family. And that is where bloodline planning can come in. So what we can do is set up a trust for you that pours into a sub-trust, like an inheritance trust for a son or a daughter. The inheritance trust is protected in a variety of ways. It's insulated from creditors, it's insulated from lawsuits, and from divorces. And when the beneficiary passes away, it goes directly through the bloodline to the grandchildren or whomever you may designate. So again, you can create an inheritance trust, also called a heritage trust, for your son or your daughter that insulates and protects assets from creditors, from lawsuits, from divorces, and keeps assets in the bloodline for the grandchildren. But sometimes it's not just about protecting assets for the beneficiaries, it's about protecting assets from the beneficiaries as well, because you really want the inheritance to last, right? You want it to last a lifetime, or at least a very long time. And the trick there is setting age limits. They say if you give an 18-year-old $250,000, he's not going to have it when he's 19 years old, right? So we put some age restrictions on trusts. We say, yes, a young person can inherit money. And yes, it's protected in all the ways we talked about. Creditors, lawsuits, divorces, we can do that. But they don't get access to it until a certain age. Usually that age is 30, but you can make it any age you want. Until they're 30, someone else, maybe a trusted family member or friend, is acting as the trustee. And that trustee can give them money for college, for grad school, for buying a car. The trustee can use their discretion to say, yes, this young person can inherit money, or no, they should not inherit money at this time. And the trustee can gift out accordingly. And once they reach the designated age, they can go ahead and have unfettered access to the inheritance. Sometimes, though, it has nothing to do with how old or how young a beneficiary is. Sometimes it is simply that they're not responsible. Maybe they have a drug or alcohol problem, or a gambling problem, or a shopping spending problem. There may just be some reason why it's not a good idea to give a young person unlimited access to their inheritance. And if that's the case, we can use trusts to devise a plan to really stretch out and extend the inheritance and make sure it lasts a lifetime. So I just want to mention that there are many ways that trusts could be crafted. We could get creative with the language, and we could really make sure that the beneficiaries will inherit in the long term, and it will last. Want to cover second marriages because that comes up a lot. The so-called Mike and Carol Brady situation, right? The husband has 3 kids. The wife has 3 kids. The second marriage later in life, all of the kids are now adults. There are separate assets, but the husband and wife have kind of merged everything. And the concern is you can't rely on the simple will in that situation. The simple will is known as the I love you will. The husband leaves everything to the wife leaves everything to the husband. The problem there is it creates kind of a morbid dynamic of who's going to die first and who's going to be the survivor. Because the survivor will end up with everything, and the survivor will ultimately be able to do whatever he or she wants, including gift it to their own children, favor their own kids, change the plan, whatever the case may be. So if you're concerned about that, there are a lot of tools we can use in these second marriage situations. Namely, we can make trusts where it secures the residence for the life of the surviving spouse. So the surviving spouse will always have a place to live. It secures some funds and some income, a stream of money for the surviving spouse. But at the same time, we can use a trust to make sure that the money will last for the surviving spouse and ultimately end up with the children as well on both sides of the family, regardless of who dies first and who's the survivor. So if you want to make sure things are equitable and fair after both spouses die in a second marriage, a trust is a really strong option. Got some questions here? Nope, we covered those. Okay, if anyone has questions, the toolbar at the bottom, the Q&A, you can go ahead and ask, feel free. But we are going to move on now to part 3, which is about Medicaid asset protection. So there's a few things I want to cover here. The cost of long-term care is extraordinarily steep in New York State, and the Hudson Valley is no exception to that. We're seeing nursing homes usually between $12,000 and $16,000 a month. It can actually be much higher than that depending on the circumstances, but the cost of care is just very high right now. And we look at strategies to protect assets, right? Now, one of my favorite strategies is long-term care insurance. It can pay for nursing home care. It can pay for at-home care. It could pay for care out of the state, sometimes out of the country. It could pay for assisted living care. It's got almost complete flexibility. There's all kinds of policies out there now. Some of them have death benefits. We've got great names, great people we can refer you to for that. But we also understand many of our clients can't get long-term care insurance. They cannot practically afford what long-term care insurance costs. And that's okay. We understand that. It is very expensive. It's very difficult to qualify for after a certain age. We know not everyone's going to have it. So we look to other asset protection tools, specifically the Medicaid Asset Protection Trust, the MAPT. You may have heard about this before. It's an irrevocable trust that shields and insulates assets from long-term care and nursing home costs. The idea here is that you want to protect what you've got, whether it's your family home, your residence, whatever it may be, you want to protect those assets. And what you do is you set up an irrevocable trust. So people ask me, this is always a question, what's the difference between a revocable trust with an R and an irrevocable trust with an I? They both can do everything we've talked about so far today, but a key difference is that if you're looking for Medicaid asset protection, you need to go with the irrevocable trust and you need to follow the rules. One of those rules is that you can't be the trustee. On an irrevocable trust with an I, you cannot be your own trustee. It's usually your son, daughter, niece, nephew, someone who's close in the family. It could be a family friend or a professional trustee, but you need to name someone other than yourself. Picture the trustee as like the CEO of the company. The trust is the company. The trustee is the CEO of that company, but you don't lose all power. You're like the board of directors. I like to emphasize that the irrevocable trust is a lot more flexible than its title suggests. It can be kind of off-putting to hear an irrevocable Medicaid asset protection trust. People think, oh no, I'm locked in, I can never make any changes to it, and it's really not true. You make the trust, and then you fund the trust. You decide what should go into the trust. The residence almost always goes in. It just makes sense, right? Because the residence is always accessible to long-term care and nursing home costs, susceptible, to long-term care and nursing home costs. The residence is always an asset that people want to pass down in the family, and it's always something that you would go through probate if the deed isn't changed. So the residence is almost something that always goes into the trust. Beyond that, it varies. Some people just put the house into the trust, and some people put a whole lot of assets into the trust, be it brokerage accounts and investments or other sorts of vehicles. And the idea is we work with your team. We work with your financial advisor. We work with your accountant. We make sure that the trust is funded appropriately, exactly as it should be, because we want your assets to be protected. And everyone's situation is different. IRAs, 401ks, 403bs, other qualified retirement accounts do not go into the trust because they are exempt and protected by New York state law. So I just want to emphasize again, any qualified retirement account is exempt from Medicaid in New York state. They also avoid probate because you have designated beneficiaries on those accounts. So to the extent that you have qualified retirement accounts, those are okay, but other assets are exposed, and we, like the house, and we look to put those into the trust. Now, the other thing to be aware of is you can change it. I was saying before, there is some flexibility. You have the right to change the beneficiaries. You reserve that right to remove beneficiaries and change them during your lifetime, even though it's an irrevocable Medicaid asset protection trust. You also have the right to fire and remove your trustee. Now, I don't recommend this, and I rarely do it with clients, but if you're having a real problem with your son, daughter, or whomever you named as trustee, you can kick them off the trust. You can fire, remove, and replace them with somebody else. So if you're concerned about that, you should know that the trustee is replaceable. It's not a fun process. It causes strife within families. We hate that. We tell you to choose a trustee you trust the first time, but you can remove that person if you would like. Lastly, I would like to mention on this topic that you can revoke an irrevocable trust in New York State. The word is actually a misnomer. If every party involved to the trust signs off under the Estates, Powers, and Trust Law, there is an avenue toward canceling out the trust. I want to take a minute and address questions here. Is income tax due upon the transfer of assets to a Medicaid asset protection trust? Okay, so the answer is it a taxable event to make a Medicaid asset protection trust? The answer is no. These are grantor type trusts, which means that they're still part of your estate for taxable purposes. So to the extent that you put a brokerage account into the trust and it earns income, that income is still a part of your yearly income. You're entitled to take income, interest, dividends out of the trust, and that income is still a part of your yearly income. So it is not a taxable event to transfer property into a trust, not at all. That does bring me to a good point. The rule of the Medicaid Asset Protection Trust is that income flows out, but principal stays in the trust. So if you've got a house in the trust and it's rented out, the rental income can go out. If you've got $100,000 in an account in the trust and it earns interest or dividends, those interest or dividends can flow out, but the $100,000 stays in and the house stays in. So I like to emphasize principal locked in the trust, income can flow out of the trust. But no, there's no tax consequences to making the trust. It's still in your name, still part of your taxable estate. The estate tax exemption, I should also mention that, is over $5.8 million on the state level, over $11 million on the federal level per person. There's lots of fun planning we can do. If you have a taxable estate, we should really talk about it. There's lots to discuss and lots to do, but fewer of our clients have to deal with the estate taxes with the exemption being so high. Okay, so we answered that one. Okay, the question again is about 401ks and qualified retirement accounts. Do they have to go into a Medicaid asset protection trust? The answer is no, they do not go into the trust. They are protected automatically by New York state law. So any qualified retirement account is exempt and protected under New York state law. You do not have to put them into a Medicaid asset protection trust. And you take the required minimum distributions after the necessary age. But other than that, the principal of the retirement account is safe. Okay. And one more question. The question is, when the surviving spouse is being cared for, who is administering the money, and what are their abilities in terms of spending? So that's a good question. It's governed by the documents put in place. So do they have the untethered or unfettered ability to spend? No, it's within reason, but at the same time, it also depends, what does the trust say, or what does the power of attorney say? So it's so important to make documents in advance while you're healthy, well, and competent to make a trust, make a power of attorney, resolve these issues for your family, explain to them, tell them what you'd want in the case of a long-term care situation so they know how to use your assets and resources to best serve you. Having those conversations is really important. If you don't have the documents in place, it ends up in a court proceeding called a guardianship proceeding, which is something that we try to avoid. Medicaid eligibility and emergency Medicaid strategies. I do need to talk about the 5-year look-back period. We didn't address that yet today. You've probably heard of it if you've done any reading about Medicaid. When you place assets into an irrevocable trust, you need 5 years to pass before they are exempt, because Medicaid looks back at all gifts, transfers, and movements of money for a 5-year period. So when people ask me, when's the perfect time to make an irrevocable trust? The answer is obvious, right? You do it 5 years to the day before you go into a nursing home. But no one can predict the future. No one can say. So 60s or 70s is typically a good time to set up a Medicaid asset protection trust. We've done it for people much younger, people with serious health concerns who wanted to get the ball rolling. We've done it for people much older, clients in their 80s or even 90s who want to get started, and we've had people make it through the 5-year look back period and live into their 90s and 100s. So there is no wrong time to set up a Medicaid asset protection trust, but we'd like to do it while you're healthy and well in your 60s or 70s. That's the optimal time to really think about it. The 5-year look back period is important in that when you go into a nursing home, you apply for Medicaid, they look at every bank statement, financial transaction going back 5 years or 60 months. So we're in June of 2020. We're talking about going back to June of 2015 and all of your assets and transactions at that point, from that point forward. So something to think about. There are emergency Medicaid strategies. I really like to emphasize that as well. So emergency strategies meaning that it's never too late to consult an elder law attorney and discuss these topics. We really like to emphasize there's always something we can do. The best time to consult an attorney is 5 years in advance, while you're healthy and well. But if someone comes in and they say, my mom's going to a nursing home tomorrow, what can I do? There are still strategies we can use. We can usually protect about half of the assets on the nursing home doorstep, so to speak. So as someone is going into a nursing home facility, we can still protect assets. So I want to emphasize that. And I also want to emphasize that there are other programs such as community Medicaid. Community Medicaid means care in the home, which doesn't have the full 5-year look back period. But as people have been bringing up at these webinars and elsewhere, there is a new law going into effect about community Medicaid this fall that is going to impose a look back period of 2.5 years. So there will be a look back period on the community Medicaid for home care that has not existed before in New York State. So something to realize, you can get care at home, age in place, receive an aide or attendant to come to your home and care for you through Medicaid, subject to an evaluation of your needs, subject to availability, and subject to, coming this fall, at least a 2.5-year look back period. So there are other Medicaid avenues to take. A nursing home is not the only option out there, but you should be aware that there are advantages and drawbacks to everything. More questions. Is there a look back period for home care? We just covered it. Not yet, but almost, but there will be very soon. If you have long-term care, this is a very good question. If I have long-term care insurance, is it necessary for me to set up a Medicaid asset protection trust? The answer is maybe, maybe not. Oftentimes not if the coverage is sufficient. Oftentimes it's totally fine to stick with your long-term care insurance and not set up an irrevocable trust. But what we would do is we would look at your long-term care insurance. We'd look at the benefits page and determine, okay, this is good, this is going to be enough, maybe this is weak, and we can analyze what your needs and shortfalls are and see if you're covered enough or not. And if you are, maybe there's other things we might do for you. Power of attorney, healthcare proxy, living trust that's not irrevocable. There's lots of options out there. So it's still worth having a consultation about it. But yeah, you might not. You might not set up an irrevocable trust in that instance. There's so much more we could say. The seminar could be 2 or 3 times as long, but I do want to get toward wrapping it up here. So I want to discuss the J&G method. Free consultations and free follow-up consultations. We can do them at the office. We are reopened. We can do them on Zoom or FaceTime video chat. And we've been doing the majority of them on Zoom and video conferencing lately, and it's been going great. Happy to have these consultations. They are all with me personally, so I'd be happy to meet with you, talk, discuss what your needs are, and move forward from there. The consultations are free and without obligation. We don't pressure you. You move at your own pace. And sometimes people do a consultation and then come back for another one in a few weeks, and then they move forward. Sometimes people want to move forward tomorrow, and that's okay too. We have the bandwidth to handle that. And sometimes people say, I can't even contemplate my own mortality. I'm only 91. I need a few years. And that's fine too. Everybody moves at their own pace, and we don't pressure people. We will work with you when you are ready to work with us. The consultations are free. The execution of the estate plan is when you pay. We don't charge you before you sign. And basically how it works is We go over the drafts with you page by page. We translate legalese into English. We make sure you're comfortable. The fees are flat fees. There's no hourly billing for estate planning. I want to emphasize that. None of our estate plans are billed by the hour. We charge flat fees. It's not based on how much money you have. It is not a percentage of your assets. It's purely based on the type of work that we're doing. Is it a revocable trust? Is it an irrevocable trust? Is it for Medicaid planning? How many deeds or properties are we transferring into the trust? What's the nature of the beneficiary section? That's what goes into calculating the flat fee. We don't give dollars and cents on the webinars, but I'd be happy to talk to you on the phone or on Zoom, do a free consultation, and I'd give you an exact quote at that time. Let's see, there was a question. There's a question on the table, and we'll just address this. How easy is it to take money out of a Medicaid asset protection trust for an expense? How is it done? So we strategize with our clients so that they have plenty of money outside the trust. The idea is not to put every dime you have into an irrevocable trust, because it's not all that easy to take money out. You could take income, interest, and dividends out, but the principal stays locked in the trust. So when people say, I need money for this procedure or this cruise or whatever the case may be, you know, we've planned with them. We've worked with their accountants, financial advisors. We've made sure they have plenty of cash in checking and savings and other accounts outside the trust so they can go ahead and spend that money. We rarely see a case where a client says, I have no money, all I've got is the trust, because we work to prevent that. We don't want to see that. But if somebody absolutely needs to get at the money inside their irrevocable trust, what they can do is they can gift it out to the beneficiaries. There is a provision called the power of appointment that permits them to gift and transfer money out to the beneficiaries, and those beneficiaries can use the money to for really whatever purposes are necessary. So in the event that it's absolutely necessary to get money out of an irrevocable trust for Medicaid purposes, it can be done through gifting, which should be done the right way by consulting an attorney. And it's certainly something we could discuss more privately. Okay. I would like to wrap up by explaining how we continue to support the plan. So at Jacobowitz and Gubitz, it doesn't end when your estate plan is signed. The relationship doesn't end there. We don't just hand you the documents and say, have a nice life. We want to stay in touch with you. We want to really build relationships with you and your family. That is so important. So what we do is we continue to monitor, maintain, and review the plan. At least every 4 years, you'll get a little postcard in the mail or an email from us that says you're invited to come in or video conference for a free review of your estate plan. And at that time, we go ahead and we ask you, anything new? Did you win the lottery? A couple of our clients have, by the way. Did you have any new grandchildren, or have your assets changed? Are you thinking about moving, selling your house? Is anything new? And does the plan need to be changed? Most of the time it does not, but you know, we want to stay in touch with people and make sure the plan is accurate, up to date, and reflective of their wishes on an ongoing basis for the rest of their lives. So these reviews of the plan are free. They happen at least every 4 years. We want to really stay in touch with our clients, so we give them the ability to review their estate plan with us. We also don't charge, again, as I said, for phone calls, emails, questions, or office visits. Every year after Thanksgiving, people seem to break out their estate plans, and on the next Monday, I get all these phone calls. What does page 7 mean? You know, what about, is cousin John in the trust? I need to understand this. And you know what? It's totally fine. We don't bill for our time when it comes to monitoring, maintaining, and supporting the plan. Our clients are like family. We want them to really understand that we are going to support those plans on an ongoing basis. Okay, so please allow us to reach out to you. I believe you'll be getting an email very shortly with this link, but you could also just go to this website. It is jacobowitz.com/webinar. Again, that's Jacobowitz, Jacobowitz, wagner.com/webinar. We'll leave this slide up for a minute, but we'd like to reach out to you. Again, the consultations are free. So if you give us your contact info, we will schedule a free consultation on Zoom, or if you prefer, in person, and we will talk to you about what your needs are with regard to estate planning. We'll give you a quote on what we would charge. There's no obligation, but we'd encourage you to reach out. Again, the consultations are with me personally. I'd also encourage you to check out our website. We practice more than 35 areas of law. Our office is located at 158 Orange Avenue in Walden. We can help you with many, many different types of legal needs. So it's just something to keep in mind. But once again, I really do hope to meet with many of you guys from this webinar. So go to this website to check in with us and give us your contact info. You'll also get an email about this that you can reply to in a little bit. I've had fun today. I really enjoyed doing these webinars. It's different from the in-person seminar experience, but we're really adapting and making it fun and interactive. I want to thank everybody who asked a question. I want to thank everyone who attended today, and we really hope to hear from you and see you soon. Thank you and have a good night.